So that, like I said, the chain of events seldom changes from the 4 that are listed. And, you know, if you think about it, and I think you've all heard this, the commercial will say, has your family member been wronged in a nursing home? XYZ Legal is fighting for the rights of your loved one. And, you know, we hear that so often. And here's another example I want you to think about. A resident comes in with gangrenous toes. He ends up dying. The son's called. The son comes in and he finds his father missing all of his toes. They have actually rotted off, and no one in the nursing home called him before this. He finds out about it as he's looking at his father's dead body. So what's the highest litigation ever received? From my investigations, it's $312 million for the family of a 69-year-old who was awarded funds for what he might have earned had he lived to 85, and he had been viable and had been still working full time. So facilities, insurance carriers, and professionals are at risk. Patients victimized by bad decisions of their MCO do have a right to sue. But there's also Federal Employees Retirement Income Security Act that may limit to state medical liability lawsuits against the MCOs. So with some exceptions, current law requires such lawsuits to be filed in federal court where damages are limited to the value of the denied benefit. What I'm telling you here is who's at risk: administrators, DONs, and any other professional can be charged with wrongful death, and they have been in a lot of states. And this has not been allowed up to now in Iowa, but who knows when it might be. Certainly conditions and concerns differ from what the attorney looks at and what our family members expect. Document the wonderful stuff you're doing. We don't do that often enough. Keep all your policies and procedures and your reference books, as standards of care and practice do change. What we did even 5 years ago may not be the standard today. You know, I talked to you earlier about how long I'd been in practice, and I can tell you when I had that nursing home in Denver in 1973, I wrote the weight was 118, they're eating good, see ya. I mean, honestly, it was 1 or 2 sentences, and that was it. That was the standard of practice back then. The standard of practice for wounds, heat lamps, tie the buttock to the bed to get, you know, if that's where the wound was, and use preparation H as a treatment or betadine. Look at how we have come along. Even in diets, look at how strict we were with the diabetic diet when even 20 years ago, 30 years ago. And now look at, we know we can liberalize that diet. So what we did again 5 years ago may not be the standard of practice today. During a lawsuit, the attorneys and the expert witness, they're going to look at the entire medical chart. But the family is totally different. They'll remember if mom was always dressed appropriately, had makeup on, had her jewelry. Did she get her favorite foods? Did you go that extra mile? The family's main complaint usually isn't about the medical care. It's about human care. The families usually aren't qualified to know if medical care is good or bad, and they may not have an opinion on that anyway. What they will recall is the way they and their loved one was treated. And it's so important that we all know the families. That, you know, but unfortunately, what starts the ball rolling in a lawsuit is bad wound care, inadequate nutrition and hydration, staffing patterns, physician order procedures, infection control, many other topics. According to Health Affairs, and this I just got out in the last couple of months, The plaintiff receives compensation in 88% of all cases involving nursing home. That's 3 times the success rate of medical malpractice claims. And if a jury trial, the plaintiff has a 75% chance of compensation, with the average amount well over $400,000 per claim. So my question to you is, do you have malpractice insurance? Especially if you are a consultant, but even if you are employed by a hospital or a nursing home, you will want your own attorney, you'll want your own insurance, you won't want to use that one in the nursing home, because that attorney will be looking out for what is in the best interest of the nursing home, not always you. As the nutrition expert, you need to chart smart. And remember that anything concerning the nutritional care of the resident will fall on you, not the CDM, nor the nurse, nor the physician. Everything, every intervention, every visit with the resident, every recommendation to the physician needs to be recorded in the chart. Any concern that you addressed with the nursing staff needs to be discussed with the DON and then documented in your monthly report and provided to the administrator. During the discovery, the plaintiff's attorney will try to leave no stone unturned. They will gather policies and procedures. They may require your billing documents, any food temperature logs, invoices from vendors to check for quality of the product or the number and the amounts of supplements purchased. They will look at everything, menus, and they may request the parent corporation to produce their records as well. They will look at job descriptions, staffing patterns, and workloads, as well as timesheets and work assignments. If the case involves weight loss, dehydration, malnutrition, impaired skin, and even fractures, your reports could easily be requested during this time. Any in-service training reports are often reviewed, and also in-services that you may have attended, your CPEUs that validate that the recommendations you have made are things that you learned at conferences that were peer-reviewed, evidence-based, science-backed. You can bet they will request policies and procedures from the time of the incident. So do you know where those old files are kept? Remember, we're talking about 2 or 3 years earlier. And where are the temperature logbooks? What's your policy about keeping them? You know, is it 1 year? Is it 2 years? What's your policy on records? The previous 2567s will be gathered to see what other problems DIA identified and how could they take these to make their case stronger. And think about call light records, broken beds, broken Hoyers, broken dish machines. Maintenance repair books can tell a story that doesn't help us any. Other items often demanded during the discovery include other lawsuits involving the facility, or if you or any staff member have been involved in another facility's lawsuit. Any fine that's been levied upon the facility in the past, anything they might find within a 990 if the facility is a not-for-profit. So maybe the CEO and the CFO are married, or one of the board members is related to the CEO, or even if your spouse might be on the board of the facility. They're going to look to see what you say also in any marketing brochures. So say that you say, we provide the quality of care demanded by your loved one. We provide the quality of care demanded by your loved one. Well, in an elopement issue, they'll look at that and say, let me see now. They're also going to look at the facility design. And they'll look at long hallways or limited staff. And so did a fall happen with a negative outcome at the end of a hallway? Did a person get out that end door and the alarms weren't loud enough that everybody was at the other end of the hallway and there were no enunciators on the door alarm system, and the person walked out and was gone and wasn't found for a couple hours, or worse, had an even worse outcome? So pressure injuries are a prime target for attorneys who do this type of work. They may be an expected outcome in those with cancer and end-stage disease, no matter what we do or what interventions that we have in place. So has this been discussed with the resident and the family when the person was admitted? Did you provide the standard of care expected, and did you document what you did? Have you, as the dietitian, documented the expected calorie and protein needs of the resident and documented the estimated intake based on the intake records? And are those intake records accurate? What is 75%? Go back and look at your policy on documentation of what 50% is, what 25% is. 100% of a bowl of soup at supper or a bowl of cereal at supper, yes, they might have eaten 100% of what they got, but they didn't get anything. All right, they got very minimal, and they're losing weight, and yet the records, you look at the record, it says 100%. My policy says that 25% is one food of the major food groups. Major food groups being meat, fruits and vegetables, starch, dairy. All right. So if they only had cereal, that's one. So that's 25%. That may have been, and maybe they got a little bit of milk. All right. If they ate a bowl of soup, still 25%. If they ate their dessert and their bowl of cereal, I probably am only going to count that as 25% because I don't count dessert as really a food group. I'm looking for those items that truly add to the macro and micronutrients of that resident's diet. So take a look at that. And then, are you training the CNAs and the dining services staff on intake estimates? And are there competency records to verify this? Are there competency records? Because the attorneys are more and more looking at what were the competencies. Are they in the staff HR chart? Do you separate out those residents with expected weight loss versus those that are a surprise? Because good facilities will have less than 2% of unexpected weight loss. So I want you to think about it. Who was a surprise to you when you reviewed weight loss records this past month? And did you investigate or just blow it off thinking it was probably just a bad weight? Because all of us know that we have those. I'm here to tell you, investigate sooner than later, because there may not be a later. Dehydration continues to be a diagnosis often used by hospitals as part of the admission diagnosis. If this is not truly accurate when they return, and why would it be? How many of our residents that we send to the hospital don't get IV fluids during hospitalization? So it probably isn't true. Then it needs to be either removed or at the very least state status post dehydration, because hopefully they didn't send them back dehydrated. And if they did, they should have sent them back with an IV, because they knew that they were dehydrated. They knew when they went to the hospital, they were dehydrated because they weren't drinking orally. So, if this diagnosis isn't removed and it continues as an active diagnosis in the medical record, and if the record is eventually involved in a lawsuit for any reason, The dehydration will become another area of primary interest by the plaintiff. So make sure that there is clinical evidence of this diagnosis or have it removed. So Amy touched on this, but patients have the right to refuse. Residents still must remain stable within the limits of the resident's right to refuse treatment. So recognize pathology or just the normal aging process. So when you have a resident that refuses or makes choices not in his best interest, chart it. It's not that the patient is non-compliant. Don't chart the patient is non-compliant. Chart the patient is refusing or making choices not in his best interest. Here's an example to consider. Here's how this could be written. This writer, meaning you as a dietitian, was requested by nursing supervisor to visit with Mr. Smith. Mr. Smith is not in agreement with the approaches in the current care plan concerning his diagnosis of diabetes and the need to follow his prescribed nutrition therapy. Present care plan allows liberalized snack choices that were planned with the resident and his wife. He was found eating a candy bar, a bag of potato chips, and consuming a 16-ounce regular pop, even though several of these have been included in the approaches in his care plan at various intervals, but not to be eaten all at one time. I educated him on the consequences of his action. He stated he understood the possible consequences, but still refused to discontinue eating any of the 3 snacks today, although most of the pop and over half the potato chips were uneaten at the time of my visit. Blood sugar 2 hours later was 435 with 6 units regular insulin provided per physician order. I will continue to work with him on a liberalized diet, educating him on consuming similar carbohydrate intake at meals and snack periods, rather than consuming excess amounts at various intervals throughout the day. I will continue to work with Mr. Smith on developing interventions agreeable to him, knowing Mr. Smith still has the right to refuse any and all interventions. So I have talked to him. I have counseled him again. I have made these recommendations. We're going to move on. He's making choices. They're not the best ones. No different than when I go down the highway and I'm doing 80 in a 70 and I get picked up. I made that choice not to drive the speed limit. I suffer the consequences of a ticket. He's going to suffer the consequences of diabetes, of exacerbating his diabetes. He's still making choices. They're just not the ones that we want him to make. In today's litigious long-term care environment, it is conceivable that every nursing home in the country will eventually be sued. I don't think that's unrealistic at all. But some facilities will be better prepared than others to mount a strong defense and to protect themselves against potentially damaging results. You as well, will they, if your documentation is accurate and comprehensive, that is the key. In any lawsuit, language plays a critical role in determining the outcome. In lawsuits against nursing homes, the language used in facility documentation is often the most damaging evidence presented in the court. You just have to be careful how you choose your words, especially in policies and procedures, in your documentation, in any document that may end up as evidence in the court. Again, accurate and comprehensive documentation is all key in avoiding litigation. Facilities must decrease liability opportunities, and you as a dietitian play a role in this. Carelessly worded policies and procedures, as well as poorly written plans of correction, often the only evidence attorneys need to prove their case against you. Expert witnesses will always ask for those policies and procedures. It's the easiest way for the plaintiff's side to win if your charting doesn't show you followed your own policy. Documentation of the resident's condition on admission is critical or prior to admission. Are nurses looking for deep tissue injuries on sacral areas, on heels, that may take 3 to 5 days to get to the surface? What about physician documentation? In some cases, failure of the PCP to return a call or answer a fax within hours set forth by your own policy. Especially now when we're looking for that risk of malnutrition diagnosis signed within 3 to 5 days. Is it coming back? The most common mistake providers make when writing policies and procedures is to use what I consider absolute language. What do I mean by absolute language? You start out and it says, it is the policy of the Nutrition Service Department to maintain safe food for all residents. Okay? It's the policy. We're going to give them safe food. In the courtroom, words such as safe and secure will be interpreted to mean a guarantee to the resident from the provider that nothing unsafe will ever happen. But in the real world, as all of us know, something unexpected is always looming. So absolute language leaves no latitude. Statements that rely on words like prevent and ensure, when taken out of context, will always come back to haunt you in legal proceedings. So therefore, you must describe the intent of the policy and procedure without using language that can be construed as a guarantee. So the policy should say, it's the policy of the Nutrition Services Department to continuously strive to maintain safe food. We didn't guarantee it. We're going to strive to maintain that, but we didn't guarantee that we would do that. So if you're helping facilities respond with a plan of correction, make sure that you're using language that doesn't lock you in and gives you a little bit of latitude, especially your plan of correction in the 2567. So I think all of you know that's the document issued by the survey agency after a facility has been found to have actionable deficiencies. And so again, you need to be careful in the language used. A poorly worded or a passive plan of correction can be a lethal weapon in the hands of a plaintiff's attorney. You need to make sure you explain, support, and defend your actions. So in a courtroom, a plan of correction with only passive corrective actions and little in the way of explanation could be interpreted as an admission of a guilt. So the best way to reduce liability exposure in the plan of correction is to thoroughly address the 4 required components of CMS 2567. So the 4 components: corrective action, identification of other patients potentially affected, systemic changes, and monitoring. So again, corrective action, identification of other patients, clients potentially affected, systemic changes, and monitoring. So let's talk about the top 10 documentation areas that I've often seen when reviewing cases. So the number 1 is lab values not addressed appropriately. I still see RDs using albumin and pre-albumin to address malnutrition when what they really are addressing is inflammation. So make sure that you don't make that error. Another one, addressing a BUN level, but not addressing the hemoglobin and how they are related. The second one is missing diagnoses, fevers, infections that increase metabolic needs, or pressure injuries, and the potential for increased macro and micronutrient needs. Or telling me the resident is eating good, but not what the calculated intake is of calories, proteins, and fluids compared to the calculated needs. What's going on with that wound? Even if it's a non-healing skin tear, and what have you done? What might cause this to be difficult to heal? They have diabetes. They use steroids. They have a diagnosis of PVD. Why isn't it healing if you're giving adequate protein and calories? certainly no follow-up from the doc on recommendations that you made as the nutrition expert. Using a diet that has no evidence-based research or is not science-based. You know, I could name quite a few, but I think you all know some of them. Care plan is so generic or is not kept up to date. If you're using diets in it, make sure the diet change was made and but I see the old diet still there. Providing grapefruit when a statin is in place or an antidepressant with no note as to why you're allowing that. Maybe it happens to be the resident's favorite breakfast. He's always eaten it for the last 80 years of his life. So he still wants it, even though he's on a statin. But you've talked to him about that. You've addressed it with the pharmacist and with the physician. So it's okay. Residents at high risk have entire quarters without notes. You know, making it difficult for me to determine the condition and treatment of the resident during that time. Those on enteral or parenteral feedings, those on dialysis with no documentation of collaboration with the dialysis center ID, or any monthly charting on their nutritional status. Those that have pressure injuries, those with weight loss or excessive weight gain. You know, I see nothing. I am there to, you know, I only work on the side of the defense. I only work on your behalf. Make sure I have something to work with. You know, a nurse charts that the resident has a good appetite, eats 75% of meals. On the same day, the dietitian charts that the resident has a poor to fair appetite and eats only half of their meals. It's difficult to say who was truthful. Do you have a system to make sure those residents at high nutrition risk are referred to you? Do you have a basket for orders or requests? How are they getting to you in this time when you're working out of the building? Do you have a form that the CDM keeps current for you? What's your system? Because the resident listed on this slide, all of these people on the slide need your attention on admission. When was their change of condition? And then chart on them monthly until the problem is resolved. The next two slides have even more risk referrals. And I'm sure glad I don't have them all, but you know, you're gonna get the gist of all of this. Again, look at the various diagnoses that involve nutrition, as well as pressure injuries and weight loss of any time. How many times do you miss those with insidious weight loss? Think about it. You know, as dietitians, we often are the first to know that something is beginning to spiral to the end of their life because of the insidious weight loss. What are you doing about persistent changes in stool consistency? What are you doing about it? Adding fiber, taking fiber away. What is it that you have done? Taking a look at the medications. What have you done? And then what about these? BMI, swallowing, dialysis, infectious diseases, and especially those that chronically have food complaints. You need to be seeing those people. If they have chronic food complaints, their family knows about it. We certainly don't chart without a purpose in mind. The most important being the regulatory requirements, but really our purpose is multifaceted, including the legal demand, making sure we chart the continuity of care, and to communicate what is being done. Good charting is complete, consistent, accurate, timely, and objective. And here's some examples I want to go through of subjective versus objective charting. So here's the subjective. The resident is eating fair. Here's the objective. Half of breakfast is consumed, 25 to 50% of lunch, and 50% at supper. I find the resident is not meeting calculated needs at this time. Subjective, is in good nutritional status. So what are you saying? Why are you saying that? And you leave me with that. Objective, within usual body weight, lab work within acceptable limits, eats 100% per self. Another one, open area is improving. Tells me nothing. Maybe it is, maybe it's not. Objective. Stage 3 open area reduced from 1 by 1 centimeter to 0.5 by 0.5. Resident continues to drink 8-ounce serving of Juven at 10 a.m. MedPass. Here's another good one, and these are all ones I found in charts. Resident plays in his food. What does that mean? All right, so here's what you could say. Sits at place in dining room, stirs his potatoes and ground meat together, pours juice into his dessert. Gives me an idea what's going on. But here's my favorite one that I've read. Tube feeding running well. Really? Where is it running? And I don't mean to be sarcastic, but remember, these things happen and I have to defend you. So could you state tube feeding of Jevity full strength by a pump set at 60 cc's for 21 hours per day with 125 cc bolus water TID per orders. Weight unchanged from last month at 160. No skin problems visualized around the G tube. That also tells me that you are a good clinician and you are doing your job. So good charting means documenting with the ideas that there may be a lawsuit filed at any time. So follow protocols. If a problem arises, then the hospital may carry more blame than you do. Think, does your charting make sense? Or is it just following what the last person charted? And who was she mimicking? Document more than routine care. If you're visiting that resident every time you're in the facility, document that. If you're going to a restaurant to obtain the resident's favorite food, document that. Document anything that is more than routine care. You don't need to document the diet order. I think Amy went over several of those things. Those are standards of care. Document the things that you're doing over and above that. Paint the picture of what you're doing. Could I read your documentation and then go pick out that resident because of what you wrote? Or would I have 8 or 10 people that your documentation would match? At the very minimum, address the 3 vital aspects of care: assessment, intervention, and plan of care. And what is the response of the resident? Was there any significant deviation from normal? What did you know and when did you find out? Again, if you notified the PCP and didn't get a response while you were there, did you follow up or did you make sure the nurse followed up? What if you have an open area that is not healing and then the family lets you know that the resident doesn't eat meat but loves smoothies? Do you make them with peanut butter powder to add additional protein or other protein powder? How are you getting the required protein and calories into her diet now that you know she doesn't eat meat? And is it charted? Put issues and indicators you used in the chart and what recommendations you sent to the physician. And then document how you discussed these with the physician. Was it in person? Was it a call? Did you fax him? And that the doctor will either consider, approve, or refuse your plan of care. Then follow up in the chart. RD reviewed the chart and completed nutrition-focused physical exam of the resident with intervention sent to physician for approval. Noted doctor has chosen not to proceed. We'll make additional recommendations and further discussion with physician. The chart should tell everyone what you saw and what is going on, such as a lack of response. If your resident is making independent choices and is able to do so, even if you feel it's detrimental to the resident's care, then you will need to continue to document that. You are discussing the situation using various methods. The resident still has the right to make poor choices, just like you and me, but make sure you document what you provided as far as education. If you provided specific pamphlets, put them down. I saw a great case where in a court of law where they said the dietitian never gave me anything. The dietitian had given him several pamphlets She had the pamphlet and the face of the pamphlet and where he had signed that he had received the pamphlet and the date. So it's hard in the court of law to say, really, because this is what the dietitian provided you. So if you've got specific pamphlets or educational information, document direct quotes on reason the resident has no plans of following your recommendation. Keep painting the picture. Keep documenting the interventions and education you're provided that protects the resident, so there is no doubt what you are trying. Clarity leaves no room for interpretation. Make sure you review the risks of not following the recommendation and what other options are available. Let the nursing staff know your recommendations and make sure if you need to refer to speech or suggest a wound care specialist, that the right people know and it's well documented. Documentation is intended to provide a complete picture of the care and the services provided to the resident. Is that what your note portrays? Is there a clearly communicated purpose and has it been sent to the right people? Have you ever thought your note was clear and this has happened to me, and 3 months later when you reread it, you have no idea what you truly meant? So read it. Make sure you're clear and are painting a clear picture and that you even know what you meant 3 months from now. Remember, a defensible record takes the collaboration of all those involved in the resident care. That means you. It means the physician. It means nursing, therapies, the CNAs, the dietary aides, absolutely everyone. And altering the chart is much more difficult now with electronic charting, but trust me, I have seen it done. And for those of you that are still using paper charts, make sure everything is accurate and that you haven't added anything at the last minute, because they can do ink forensics to tell when that entry was made, whether it was this month, whether it was last month. And in the past, some have added notes after it was copied by the plaintiff. So it's hard to explain if the plaintiff came in and copied the record of someone that's still alive, and then when it gets to court, there's an extra note that has a date prior to when he copied the chart, and it's in there. Hard to defend you, and everything then that you've said or written is under the microscope. So think about trying to prove important facts. The average plaintiff waits 16 and a half months before filing a medical malpractice lawsuit. And then once the lawsuit is filed, it takes an average of 27 and a half months to reach resolution, either through negotiated settlement or through a jury verdict. So you get a sense how long this takes. So when you're taking care of a resident, talk to the family, the resident, the nursing staff. Get your sense of whether you need to document a paragraph or a page. If your gut is not comfortable with what's going on with the family and you, try to develop a trigger that will key your memory back 2 to 3 years. And document the time with those people that you spent with the resident and the family. Was it 15 minutes? Was it a half an hour? Whatever it was, document it in your notes. Spend a half an hour talking to the daughter about the mother's supplements and what she might eat since she's been refusing all that I've offered. Daughter suggests XYZ for the mother. All of that. All right. All of that. Remember, the ability to locate information quickly may make the difference between a good decision and a less than desirable one. So the actual forms and papers on which we document are often hard to follow or don't guide the writer. Or if you can't find the labs in the chart or you can't find the hospital record, can you find that information in the EHR? If you can't, investigate, figure out how you can, especially if you're using PCC or Matrix or any of those EHR systems. There are ways to get these into computerized forms. Replacing old systems and bad habits with new ones, that's never easy. It's just not. But it's an important step to producing legally defensible medical records. Charts need to be organized, and that means the nutrition notes, okay? This may also help jar your memory when it comes time to capture information in words. No matter what format you are using, whether it's computerized program or paper charts, always again address assessment, intervention, response, and plan every time you evaluate that resident. Will your documentation support you in a court of law? Your care and services cannot be recalled from the medical record unless you put them there. That's why your choice of format, wording, phrases is important. Your entries will be the basis of not only preserving information for ongoing care of the resident, but also creating a structured business document that reflects a complete story of that resident using information from all the caregivers. Objectively, when auditing your records, you should look beyond whether all the squares are signed and grade the medical record according to its ability to reflect your services and the resident's response to your services. Check the problems identified and the medications, the treatments, and the protocols administered. Read other disciplines' progress notes carefully. Does the chart outline the actual and potential problems related to medications, to treatments, and procedures as identified by the interdisciplinary team? Are you able to identify the types of care that you delivered and that the resident received? If you can't, correct it. We all have to chart with the idea that we are creating a defensible record. If the family states we could not get her to eat anything at home, these are the kinds of comments that you should use to identify not only the risks involved, but also it's an opportunity for resident and family education regarding the regulations that govern what the facility can and cannot do. They're telling you they couldn't get her to eat anything. You need to come back with, we are not allowed by regulation to syringe feed or to force feed, those types of things. It also lets others know that the nursing home may not be able to get the resident to take oral feeding either. All right, we may do everything we can, but they're still not going to eat for us. They didn't eat for the family either. Make sure you share this with the physician and that he reviews the comments with the family as well. And he makes an appropriate notation in that chart. Has the physician discussed the prognosis with the resident and family and what to expect from the resident's diagnosis? Or have you done it at care conferences? We should also provide a did you know education regarding potential outcomes. Weight loss with the COPD, potential for impaired skin with diabetes or CHF or COPD, as the resident may be predisposed to poor healing with many of those diagnoses. Did you educate the family on what you may and may not be able to do? And then, did you support these efforts in the medical record? So what hurts us when we use the excuse, oh, well, we were too busy to document everything. Or we tell the family, or even, I'm not sure which is worse, whether it's the family or DIA, well, we were short-staffed. Or I've also heard, I never worked with that resident, so I didn't know something, when we should have reviewed the care plan prior to taking care of that resident. Worse yet, we were flippant and say, well, everybody makes mistakes. And then again, we chart without doing our own thorough assessment and rely on what others told us. One time I read a chart and And the nurse had written, and you guys, a lot of you have heard this story from me before. The nurse had written, has his own teeth. So I'm going in to do my physical assessment, and I know that those are dentures. They are perfect. This guy is in his 80s. They are perfect teeth. So I said to him, do you have your own natural teeth, or do you have dentures? And he flips them out into his hand. And he said, well, I have dentures. And I must have looked funny. He goes, why do you ask? And I said, well, I was reading in the chart and I got the impression that you had your own natural teeth. And he starts chuckling and he said, oh yeah, that nurse asked me if I had my own teeth. And I said, well, yeah, whose teeth did she think I had? So, do your own thing, find out. So the next few slides, and you can read these too, but the next few slides I want to go over. Here's some clear documentation. Resident needs calculated at 1850, 65 grams protein, 1850 fluid related to a stage 4 open area on the coccyx and stage 3 on L3, L4. Current intake records reviewed with intake estimated at 1,000 calories, less than 40 grams protein, 1,100 milliliters fluid, receives a regular diet, which is appropriate with ethnic preferences provided. Facility provides meals from the local Asian restaurant, which are delivered just prior to lunch and dinner, which are often refused, although it was one of her favorite places to dine prior to admission to this nursing facility. Family has also been bringing in favorite foods, but resident has been refusing these. Favorite snacks are often refused. We have also tried on all of those that we have listed. Other high calorie protein dense options, as can be seen in previous nutrition progress notes. There are no identified chewing or swallowing problems. Meds remain stable with no food drug interactions. Weight loss has continued, as documented in facility weight records. It's currently 105, down 12% past 6 months. Steady consistent loss. In the past, resident and family have rejected enteral support. IDT will once again discuss at upcoming care conference. Labs show slightly elevated BUN, possibly related to diminished fluid intake, low albumin, and normal lights. Presently, we are unable to meet the resident's calculated needs for food and fluid intake due to the personal choice of the resident, even though we are providing residents' favorite foods and purchase meals from the resident's favorite restaurant. We will continue to work with the resident and trial other calorie-dense foods, fluids, and supplements, hoping to identify something she will accept. Present care plan goal for white stability is not met. So then we have the care plan, and the care plan note says, the family stated understanding and wishes no aggressive nutrition support consistent with signed advanced directives. Family was updated on condition at care plan meeting 115. The physician has been notified via fax on 115 after meeting with the resident's representative, family, and IDT, including social worker, CNA, nurse mentor, and this registered dietitian. Fax from physician returned with no change in orders. See the story that we painted? There's no doubt that we're doing most everything we could do. So what we need to do is head off legal claims. First, we need to be proactive and make sure staff is aware of incidents that might turn into a legally sensitive problem. Every incident report, fracture with major injury, elopement, malnutrition that might have led to the death of a resident, needs to be reviewed by the Quality Assurance Performance Improvement Committee within your facility, or at least a subcommittee of this group, with the idea of risk mitigation. So we will gather everything right away as if this may go to court. That way, if it does, you are at least a bit prepared. You want to use a root cause analysis approach and make sure if the staff needs training on any area that you get it done and document competencies in the employee personnel records. You want to consult with the legal counsel and put them on notice that you may have an issue. They will help you set up this process as a quality assurance project that can possibly be kept from getting into the hands of the plaintiff's attorney. Maybe, maybe not. Should a family come in with a concern, make sure you listen. Don't provide them with skin sheets or parts of the chart unless they ask for them. Just listen Tailor your response to their specific concerns. If you start talking without the entire story, you may give them extra ammunition. Listen and find out what they want. Make sure you know the state and federal rules and regulations related to nutrition care, meal service, and sanitation standards. If you know and have charted on those residents at nutrition risk and have held nutrition at risk meetings with minutes and have good systems in place to make sure you get the referrals you need and are available to do immediate assessments on high risk admissions, either in person, via fax, or with the use of telehealth, you are going to reduce the chance of being sued. Do you have strong relationships with the facility and feel comfortable with the time you are allotted? I think some of you probably saw my comment the other day on the listserv. If you don't have time to do what you need to do to make sure that you aren't putting yourself at risk, then either ask for more hours or move to a different facility. Do not put yourself at nutrition risk. Do you have definite protocols for medical nutrition therapy? Is there a policy on referrals? And is it followed? And if not, why not? Who talks to the families about the advanced directive that addresses feeding tubes? Do you have a pamphlet that you provide to the families, but who explains it and when is it done? We need strong policies and procedures related to advanced directives. When do you actually get the admission weight and height? If your policy says weekly rates, what happens if they aren't completed? How are they completed? And how is it documented that it wasn't done? How are the drug nutrient interactions communicated to the physician? Is the pharmacist involved? Is there a rift going on between disciplines and it's going on in the chart? That happens frequently, more frequently than I'd like to say. Who is responsible for making sure there is thorough documentation of everything that is done on behalf of the resident with revisions made to the care plan? Probably more important than any of the others are these last two. Having excellent listening skills, being empathetic, being trusted and respected by that family, and certainly not being defensive. That only makes you look guilty. Meal rounds, monitoring systems, accurate weights, and good communication with nursing, physicians, families, and the CDM NRD prevent lawsuits. PR, customer service, and good communication. Appetizing hot food and friendly service go a long way. Right now, if you are still using disposables for the convenience of the staff, get rid of them. COVID is killed with high temperatures and with the soaps that we are using. Protect yourself. Keep professionally current. You're doing that today. Use and expand available resources. You got 3 pages of resources today. Make sure you are at a facility that practices at the highest level possible, is not using practices that are no longer pertinent. Establish standards of excellence in your charting, in your care, and in your service. And understand the philosophy of the facility and make sure you can agree with it or consider moving. Protect yourself. Make sure you follow professional standards of practice. They will always come up in every lawsuit. If you don't know what they are, get them out. And that you don't tolerate any illegal behaviors or acts as if you do, you are as guilty as those that you ignore. Before you sign a new contract, check out what the community has to say about the nursing home. If the reputation is poor, it brushes off on you. We talked about that earlier this morning. Use the clinical pathways to audit what is going on so that you are survey ready and practice at that level or above. Make sure that dining services staff are competent and well trained, and that the competencies are documented in their personnel record. Always, always, always put the resident first and their wishes. Minimize potential for legal action by understanding your role in resident care. Making sure that charting is appropriate. Making sure that you are a team player. And remember, every individual employee has the power to determine the level of customer satisfaction in that facility. And families that get great service don't sue. I can tell you for a fact that people who sue, those families have diaries. Diaries from the day that that resident came into the facility. Comments like, well, that doctor doesn't know anything, from a dietitian when teaching a new diagnosed diabetic. Well, I would have done that, but we were short. Don't be conceived as being uncaring. Don't be conceived as taking shortcuts. I remember defending a dietitian. It was a Friday night. Her son was playing football. He was a quarterback of the football team. She needed to get out. As she's cleaning up, she notices a chart that she didn't recognize the name. She pulled it out. The chart was missing on her sheet from the CDM. She needed to chart on that. She charted hurriedly. She did not chart accurately. And the resident died before she was able to come back and correct her mistakes. She cried on the witness stand. She cried during her deposition. It doesn't make any difference. Give good service. Don't be conceived as being uncaring. Families that get great service don't sue. They trust you, and they know without a doubt how much you care. Can your family say that today, when they visited, they dealt with a dietitian who was kind, caring, and compassionate, that showed sincere concern and empathy towards them and their loved ones? Can they say they saw team players who did whatever the resident asked and that showed their love through their professionalism, their actions, and the way they communicated? Were we all advocates for their loved ones? That's the true standard of care. Happy families don't sue. So keep the resident and the family happy. It's what we got into this field for. It's our goal. It's what makes us happy too. And it does make a difference. Thanks a lot for this. This is a tough presentation to do, and a tough presentation to listen to.
It's wonderful, Kathleen. I think it's good information. I think it makes you think about the time we take for documentation, and so I think it'll be really well received. Does anybody have any comments for Kathleen?
So I see there's one about, was told they need to use disposables as residents are out for communal dining. Is this correct? No, it's not correct. They can use real dishes. The only state that I know of that has a regulation is New Jersey, and they can use, this is a crazy regulation, they can use regular plates, but they can't use regular silverware or regular glassware cups. So
I think our chapter 58 also tells us not to be using disposables.
It does.
And also during COVID, we have to make sure we're taking the temperatures, making sure your logs are up so we know that we are properly sanitizing our dishes.
Right. The only ones that we have used disposals for are those that are positive COVID, and that was because of being able to, was easier than and safer, and how we documented it was the safeness for our dining services staff that are doing dishes. Because if you bring the dishes that are in a COVID positive room back into the department, all right, you need to make sure that that person that's on the dirty end of the dish machine is completely gowned, goggled, everything because of the spray, and should have an N95 on. Because when you're using the spray nozzle to rinse off those dishes, you have aerosol in the air. So you would want to have that person, and probably the person on the clean end, because of the shortness of the distance, you would probably want both of them in an N95.